Hello, everyone. This is Paula Marie Young, award-winning mediator and legal educator whose purpose is to teach people negotiation and mediation skills so they can live happier lives, solve problems more effectively, and resolve conflict holistically with wisdom, skill, and heart. So today we're going to be talking about the preliminary stage of the negotiation process. And this is a very important part of the process, even though I don't think it gets a lot of attention sometimes in training courses. And in fact, in my own dispute resolution class, I told students that I would provide most of this information by webinar because it does cover quite a few topics, all of which are important, but often are most important right before you're ready to go into the negotiation. So one of the things that I do have my students do is that they go through an exercise. It's in the form of an exam, but I also call it the capstone negotiation pre-planning document. And my hope is by the time they go through that pretty arduous exercise, they really have a much deeper understanding of not only the facts, but also the legal positions, and more importantly, the underlying interests of the parties and the potential strategies that they're going to take in that negotiation. So without any further delay, I'm going to go get my slides. Give me just a moment. All right, so as I said, we're talking about the preliminary stage. And just to put this in context, remember that there are several stages of the negotiation. And I would actually put this pre-planning stage in this step of the process. It's both rapport building as well as actual preparation for the negotiation. And then the other steps are information gathering and interest identification. Each of these steps may get a different name depending on who's writing about them, but conceptually, this is what you're covering. Then you've got to set an agenda based on what you've heard in this earlier process, especially the interests that become apparent during that conversation. And then based on that agenda, you're going to do option generation. This is something where you want to try and stick to particularized ground rules, which I talk about in another webinar. And also, stay on the right side of your brain, the creative side of your brain. And then in option evaluation and selection stages, you're actually shifting over to the left side of your brain and you're bringing your analytical, linear, logical thinking skills to evaluating and then selecting the best option. And then finally, there's some sort of closing to this process, typically the drafting of a memorandum of agreement or the actual agreement itself. So let's go back and recall the 4 basic points of principled negotiation. This is coming from Getting to Yes. The first one being separate the people from the problem, and we've talked about that a lot in terms of enhancing communication skills and understanding the different negotiation styles and being able to address those. Also, understanding hard bargaining tactics and not only anticipating them, but having appropriate responses to them. The next one is focus on interests, not positions. And we spent 2 days in class talking about that. And as I illustrated many times, the key question here is asking why. Why do you want something? Why does that proposal work for you? Why doesn't it work for you? Those sort of questions with appropriate follow-up. The next step is generate a variety of possibilities before deciding what to do. So that's that option generation stage, transitioning into evaluation and selection. And then finally, insist that the results be based on some objective standard. And we've talked a lot about using the Blue Book, for instance, in a car negotiation. And we're going to talk about objective criteria in a later class dedicated just to that topic. So there's different types of preparation. There's the client preparation and the lawyer preparation, and we're going to talk about those each in turn. And let me go back just a moment and say, This discussion is coming out of a book written by Craver, and he is a leading academic in this field, just to put that in context. All right. So first of all, what are the benefits of client and lawyer preparation? Well, the data certainly shows that prepared parties do better in the negotiation. You aren't taken by surprise. You know what your strategy is. You know what your alternatives are. You know when to stay at the table and when to walk away. And we'll talk about that later. Knowledge constitutes power. The negotiator exudes confidence, and you certainly want that. The opponents may subconsciously defer to you when you are prepared. So if you're exuding confidence and you're talking in a way that shows that you're prepared subconsciously, you may obtain an advantage from that. Now, we always have to prepare our clients as well for the negotiation. We don't want them to be surprised, and we don't want our clients surprising us if that's at all possible. So the first thing you've got to do is ascertain the psychological needs and interests of the parties. And we talked about psychological needs in class 6, and we've talked about interests in a couple of classes in this module. You want to set expectations. And a lot of times clients will come in with very inflated expectations about the value of the case. And so often after you've built trust and rapport with the client, there's a certain amount of reality testing that you have to do with the client so that they know what a good outcome might be for settlement and why they can view it as a good outcome. You have to ascertain facts and their aspirations and their priorities. So what do they absolutely have to have? What's important to them? What's desirable? And what can they give away to build momentum in the negotiation? Now, you'll remember that in the hard bargaining tactics class, we talked about every concession should still look like it is a big deal to you, even when you're working with giveaways. So interests, again, asking why. The lawyer should not substitute his or her own interests or values for those of the client. So it has to be a very client-centered approach when you're doing this. That's not to say that lawyers don't have their own interests, but you have to be careful that they're not in conflict and that you are there to serve the client. And as I said, ascertaining psychological needs. So these are things that can or cannot be met through the negotiation, but certainly are going to color the negotiation. You've got to figure out the BATNA, the best alternative to a negotiated agreement, the MALATNA, the most likely alternative to a negotiated agreement, and the WHATNA, the worst alternative to a negotiated agreement. And when we're talking about all of these, the negotiated agreement is what you could get at the table with this particular party. So the BATNA is what you would do with someone else, and the WHATNA is what you would do with someone else, only it's something you really want to avoid if at all possible. You also want to try and anticipate in advance the options at the table so that you can increase your bargaining strength. So if you can see a lot of different ways to get your interests and needs met, it gives you flexibility. And in our hard bargaining class, we talked about alternative value packages or different packages to give people a lot of options when they're picking an outcome. You want to be careful about unduly raising client expectations. So earlier on, we talked about setting expectations. In some ways, you do want the client to be aspirational because the research shows that people that are more aspirational do better in negotiations, but you don't want their expectations to be so high that any settlement offer is going to be viewed as a significant loss, because people want to avoid losses if they're framed in that way. So we want to acquaint clients with the procedural stages of the negotiation so they know what to expect, and you can do this maybe through a little webinar or through a handout or a package or even an audio tape of some sort, audio presentation that they could listen to when it's convenient for them. So you want to explain how the process is likely to unfold, what the roles are for each of you, decide how actively the client will participate in the negotiation and in what stages. So one question is, does the lawyer open the conversation, or do you want the client to open the conversation? And sometimes it really depends on the strength of the client in terms of their communication skills, their emotional presence, I guess would be the right word. Sometimes having a highly emotional client, depending on what those emotions are, can be very beneficial. If you've got somebody that gets angry very quickly, then you may want to put them in a position where they don't have to participate quite as much, or they can get angry in a private room somewhere and then come back with a little more composure. A lot of times clients will opt to have the lawyer take the dominant role because in some ways they are paying the client or paying the lawyer to be the client's voice. And it depends on the stage. So at the beginning, there's going to be introductions and perhaps some way of building connections between all the people that are at the table. There's going to maybe be shared information gathering and interest identification. I can see both lawyer and client doing that. In what order, I think is something you can decide. Agenda setting, I can see that as being predominantly a lawyer activity. Option generation, I can see this as predominantly a client stage of the process. And these two, I think, again, are going to be joint sort of efforts. And then the closing, typically it's a lawyer process with the client reviewing that final written work product. So what's a lawyer need to do to prepare for a negotiation? Through knowledge of relevant legal and theoretical doctrines. So the point being here that we bargain in the shadow of the law. The law may only be one value that we're bringing to the table, but it's an important one because it often colors the kind of alternative you have, whether best or worst, to a negotiated agreement. And let me step back and talk about why law is just one value. So I tell the story about a client that I had whose home was damaged in a windstorm over St. Louis, in which a microburst came out of the sky and literally just picked the roof off his shop area where he had all his very expensive masonry equipment. He was a professional mason. And we ended up taking that case to arbitration on the site so the arbitrator could see what had happened. And unbeknownst to me, he had promised his wife, who suffered from an anxiety disorder, that she would never have to testify. And so I put him on first. It was very persuasive testimony. I had done a lot of homework as well that supported what he had to say. And the insurance adjusted offered 100% settlement in that case, plus our attorney's fees, before the wife even had to testify. Of course, I still needed to talk to the client, so we went down to the basement and huddled together, the three of us, and he accepted the deal. And I said, you know, I do think I could get some more money out of them for bad faith insurance practices. They said, no, this is fine. Don't worry about it. Well, it turned out that it was more important to him that he make his wife comfortable than it was to get more money. So that's an example of a different value having a very dominant role in this negotiation, unbeknownst to me, as it turned out. All right, so you've got to develop cogent theories of your case, which is, again, reflective of your legal theory, what is a possible legal theory. You've got to anticipate counter arguments of the opponent. So this is like a lot of the work that lawyers do. You still have to anticipate how the opposing party is going to come at you in the negotiation. And the pre-planning document that I have students work through really forces them through that process. And by doing this in advance, it will boost your confidence. You'll know if somebody's trying to take advantage of you, you'll know that it's just a negotiation ploy. And a good example of this is the Hollywood divorce negotiation on the DVD that was created by Hastings Law in a DVD called Difficult Negotiations. And in that case, one of the lawyers came in and tried to assert that California was not a state in which marital property would be shared equally. All right, so you want to determine the expected value of the transaction. So you're going to be using objective criteria. You're going to look at all your possible BATNAs, and you're going to be prepared to strategically disclose your BATNA in the negotiation. So we've talked throughout the class about the tension between trying to keep things secret because you don't want to be exploited, especially in the distributive or money bargaining stages of the negotiation, but disclosing enough early on that you can get your interests and needs met. So there's always that tension there. And I think it becomes safer sometimes to make those disclosures, certainly as you develop a relationship with the opposing parties and as you gain more information. So you do need to keep in mind that there may be a moment where talking about what your best alternative to that deal at that table is can enhance your leverage in that negotiation. All right, so you never want to enter an agreement that is worse than your BATNA or your MELATNA. So if you can do a better deal with someone else, you should go do that deal. And if you can do a deal that with someone else that is your most likely alternative, then go do that deal too. You always want to walk to your BATNA if the person that you're negotiating with is not giving you what you can get elsewhere. And at the same time, you have to stay at the table if you have no BATNA or you only have a WHATNA. So a good example of this in the litigation context or the legal context is you really want to do the deal. There's lots of reasons for doing the deal. And in fact, if you had to litigate the case, you have some serious worries that you might lose. So anything at the table is potentially a better outcome, even if it's fairly modest, than going to trial and getting a zero recovery there. All right, you need to understand and communicate the real cost of non-settlement to clients. So a lot of times they watch TV, they see these big verdicts. The newspaper tends to only report the big verdicts. They don't report the cases in which someone got zero. And so clients really have a hard time getting their heads around what would happen if they don't settle the case at the table. And so one thing that you can do is you can use decision trees, which is really an advanced topic. I do teach it in upper level courses. Or you certainly can rely on verdict reports if they're available to you on the topic that you want to discuss. And we're going to be talking more about those in the objective criteria class. They have to factor in the monetary transaction costs. So in a litigated case, you've always got the lawyer's fees through trial, all the discovery expenses, which is increasingly more expensive if you're trying to discover email communications and other electronic data, just because of the sheer volume of it anymore. And then you've got your expert witness fees, which of course tend to be very expensive. You also need to calculate the time value of money. So this is, if you're paid now and could invest it, what is that money worth versus what you might get at a later date? And sometimes taking a lower amount and putting it in an investment that's doing well is a better choice than waiting for more money later on in the process. So you have to, if you're a plaintiff, you have to subtract all of these costs from the expected verdict at trial. And if you're a defendant, you have to add these costs to the expected verdict at trial. And this helps you get a much better read on what is the true value of any offer on the table during settlement. And you also have to consider the non-monetary transaction costs. And people don't often do this, But being in the middle of litigation can be very stressful. For most people that have never sued anyone, this is a very stressful process. They're going to be waking up every morning, eating their Cheerios, and worrying about that litigation and kind of ruminating on the other side and how miserable they're making their lives. And life does tend to be put on hold while you're trying to get through this process. It's not as if you're really moving towards the future. You're still kind of mopping up the past. And there's certainly the uncertainty of trial outcome. You can use decision trees to get a better fix on that. But even in the best case, if you tried it 100 times, at least once, the plaintiff might lose. The effect of litigation on relationships, personal life, and work life. So again, this is a big source of distraction and potentially unhappiness, certainly anger. So that may have a corrosive effect on the people around you. So at the same time, you have to understand the real costs of non-settlement to opposing parties. And this ties into our class on stand in the other party's shoes. So you want to determine the opponent's expected value of the negotiation. So basically, you're flipping the analysis. Attempt to understand the opponent's interests and needs. Formulate proposals that may satisfy those interests and needs. And what is the opponent's BATNA, MALATNA, and WHATNA? You want to have an accurate assessment of the strengths and weaknesses affecting both parties. And you want to avoid the tendency to overestimate your weaknesses while underestimating the opponent's weaknesses. So again, if you can stand back and look at it more objectively, you'll be better off. Excuse me. Avoid amplifying your own vulnerabilities in this process because nobody ever has the perfect case. It's a rare thing. And so they're going to have witnesses that don't come across as well, or maybe a document that they'd rather you never see, whatever it might be. What negative factors may influence opponents that they have not disclosed during the negotiation? So there may be hidden things going on, structural, relationship, maybe data-based, could be value-based, that are going to affect their side of the negotiation. And you also want to take account of their value system. So who's afraid of whom and why? So you might have a big firm going up against legal aid, which would seem to be an imbalance of power, but the legal aid folks may bring that sort of true believer commitment to the process. It's possible that there might be a bankruptcy looming, either with your opponent or your own client, so you could get a judgment and never be able to collect it, which is what I've said in the next bullet point. So assess your own strengths and do not give opponents more respect than he or she deserves. So I've said before, and I'm going to say it again, in many ways, people only have as much power over you as you give them. Now, there's lots of sources of power that may be an overstatement in some contexts, but in most contexts, we give away a lot of our power. And this is one context in which you should not do that. You should kind of stand in your power, stand centered, stand, really grounded, having done all the preparation that you need to be able to go into this with confidence. As I said earlier, it's important to establish high aspirations and elevated opening offers. And we don't really have time to talk about this in this class. I talk about it in an upper level class, but the research is really quite strong about this aspirational piece. If you anchor your opening offer a little higher, kind of a stretch, not in that insult zone, but back in that sort of aggressive zone, then you are likely to be able to have a better outcome than if you anchored lower, more towards what you think is the center of the zone of possible agreement. So generates better outcomes, guard against forming modest initial proposals, And remember the impact of anchoring. So anchoring is just, where do you start that negotiation? It starts to have a psychological effect on people. It has sort of a gravitational pull in terms of what they can expect out of the negotiation. Use principled opening offers. So even in highly distributive cases, you want to provide explicable rationales for any offers and subsequent concessions. So every concession you make, you want to be able to justify it in some way. You can hope that you've kind of planned this concession strategy out in advance, and you've got a reasonable basis for making each step. Can be tricky, but you want to try and trade things that have the kind of value that you want in terms of your overall concession pattern, but use them as justification for that individual concession. And be sure to provide a defense to the solicitation of sympathy. So you don't want them trying to get additional concessions out of you, unreciprocated concessions, just because they've developed a sense of obligation or sympathy. This would be very important, for instance, if you're a defendant in a personal injury case. Foresight and flexibility. So you want to anticipate as much as you can, but at the same time, this is a improvisational process. It's not at all like kabuki theater, which is what I use as the analogy for litigation. This is improvisational theater in which you're trying to respond in the moment, but you also at least have an idea of where this thing should be going. We talked in class 10 about different negotiation styles, and one of the things we talked about was the data showing true problem solvers and how the attributes assigned to them really created a profile of someone who had a good reputation on many dimensions: legal competence, social and emotional intelligence, reliability, trustworthiness, ethics, all of that. And so the negotiation is always easier if you're working with someone who comes in with that reputation, because otherwise you're constantly having to verify whatever somebody tells you. You're going to have to take a break and maybe go look at the objective criteria on that topic. It's not like you can just say, okay, I'm going to trust you for now. We'll check it out later. It's like you constantly have to make sure you're not being hoodwinked. Okay, in multi-party negotiations, so as you scale up, it's going to be a little more difficult. You want to make sure that you've got a coordinated strategy, and you pick one spokesperson, and you manage that inter-party communication so you don't have a lot of people giving a lot of different information in different ways to different people. You want it to be centralized so that you can control the messaging. Setting the stage. So this is something that I often talk about in some depth in class, and I think it's really important because place does affect how people feel. And so I personally want to create a really relaxing, enjoyable environment for the negotiation. And to me, this ties back to the first stage of the negotiation, the rapport building stage. And those people that have taken my mediation class know that we do the final co-mediation in my living room and dining room, and I serve dinner in between. And this is a way of just trying to show students how making those kind of choices affect what happens substantively. So you've got to decide, do you want to be in your own office where you have more control, or at the office of the opposing counsel where you're kind of conceding, all right, I'm going to make you more comfortable because you're going to have more control. I think it depends on how sophisticated the other side is. If they're trained mediators, then I'm going to trust that they are sensitive to these issues and are going to pick a good negotiating environment. You want to think about the position of the chairs and shapes of the table. So do you want a round table where everybody kind of is perceived as equal, or do you want to have a square table for a four-way negotiation? And if so, where do you put the chairs? Are they on each side of the table, or are they on just one side of the table? Whatever you have to think about in terms of trying to enhance communication across the table, but also between the client and the lawyer. And then what kind of amenities are you going to have? Are you going to have coffee service and maybe a light snack at some part of the day to help people keep their energy levels up? Are you going to take a break, or are you going to order lunch in? And do you have menus for a number of different places so it's easier for people to make a choice about that? Are you going to, for instance, take lunch break and sit out here in the sun and enjoy the view and just kind of break bread and, again, build rapport before you come back to the negotiating table? What kind of support systems are there? Are you going to have a secretary who can type things up, or maybe an associate who might be able to do some legal research? Are you going to have a computer printer so that you can type up and print out the agreement that you reach at the end of the day? Whatever people might need, a conference room, for instance, if they need to separate out and be able to call back to the office, and maybe they need a conference telephone system so that they can talk to more than one person in different places. And this might be especially true in a plaintiff's PI case where the defendant insurance company may have to contact several people before they can, for instance, sign off on the deal or get more settlement authority. All right, so moving on, assessing negotiator personalities. As I said, we talked about some of this in class 10. So Craver's advice is that if you already are familiar with your opponent, then you want to reestablish a cordial environment. And you can do that through pre-negotiation calls and saying, oh, it was nice to learn that you're representing XYZ Corp in this case. I really hope that we can work together to reach a mutually satisfied agreement, whatever. All right. If you're working with a new negotiating opponent, then you're going to have to spend time to assess his or her personal and professional identities and their intended tone for the substantive negotiations. So this might be the thing where you've got a series of phone calls, or maybe a series of pre-negotiation meetings to get a fix for how they're coming at the whole process. If you have prior familiarity with the opponent, then you're going to look for interests you share with the opponent, so you will develop greater rapport with that person. It will enhance the likely creation of a beneficial relationship and cooperative behavior. So there's some interesting research out there that says that we tend to like people who are more like us. And so what that means is it may not take very much for someone to conclude that you are more like me. It could be that you're both fathers, or it could be that you both have kids playing soccer, or it could be that you both went to the same college, or you root for the same football team, or whatever it might be. But you want to have the kind of conversation that begins to help you build those sort of connections. And when I think about this, I think about George Mitchell when he was involved in the Northern Ireland peace negotiations. And at one point where everybody was at impasse and just sick of looking at each other, he basically said, okay, let's stop. Let's just talk about what we do when we are in our off time. What kind of hobbies and interests do we enjoy? And to his surprise, it turned out that a lot of the negotiators shared an interest in opera. And so they talked frequently about that interest in opera. Okay, if you don't know the negotiator, you can also check with outside sources, including other lawyers, to get a fix on that person. No matter what, you want to try to create a cooperative win-win atmosphere. So in the wrap-up class, we're going to talk about Axelrod's tit-for-tat strategy, and we'll talk more about this idea of being cooperative, also punishing defections, but then being absolutely forgiving, and then getting back into a cooperative mode. Okay. Okay, establishing the negotiating tone. So we need to understand the other negotiators' worldview. And competitors act competitively no matter what their opponents do. So unless they've been trained, they've got this sort of automatic style, and they're not very good about picking up on anything else or even caring potentially. They see the world as people with competitors and will design a competitive negotiating environment to make the opponent uncomfortable. So we talked a lot about this in the hard bargaining class, and I hope at this point that even if you saw this happening, it would not make you uncomfortable. But cooperative negotiators are more likely to mirror the style they get from the opponent, and they see the world people with both types of negotiators. They prefer the cooperative approach because they know its benefits. And as we'll talk in the wrap-up class, a lot of times you want to lead the way. And so if you are good about setting the tone and being able to use a strategy without being exploited, you can help keep the other parties in that same sort of zone. Congenial relations generate better results, so develop positive rapport. This is the third or fourth time you've heard that. You can still be a forceful advocate without resorting to disagreeable tactics. So this again is that separating the people from the problem. So you are trying to preserve the personal relationship, so you're soft on the people, but you're hard on the outcome or the problem that you're trying to achieve or solve. The initial part of the negotiation sets the tone that is later difficult to change. So it's, there's a concept of jumping on the back of a tiger. And once you're on there, how easy is it to do something else except just hang on by the ruff and just hope for the best? And so if you can establish a different tone early on, then it's easier than trying to de-escalate from a more competitive tone. Negotiators who get the other side to like them and their client and act with respect and courtesy usually get better results than negotiators who cannot generate these sympathetic feelings. I apologize, I forgot to turn off my email, so we're going to keep hearing that interruption. At any rate, again, this is supported by empirical research. And negotiators who start in a positive mood negotiate more cooperatively, reach more agreements, and are more likely to employ a problem-solving approach to maximizing joint gains. And in the emotions class, I'll talk a little bit about how elevated emotions, even slightly, positively affect negotiating outcomes. Negotiators who start in a negative mood are more adversarial, reach fewer agreements, and tend to get less efficient overall results. They also tend to use more deceptive tactics. Now, when I read this, it reminds me of a time where I called up an opposing counsel, and basically he started biting my head off. And I had learned this trick from someone else, and I just said, "I'm sorry, did I do something to upset you?" And the guy realized in that moment that he was talking to me in the wrong way and apologized and completely changed the tone. And so that might be something that would work in this context as well. Excuse me, be careful of emotional contagion. So we know that emotions are contagious. If somebody is more upbeat and happy and cheerful, then when we're around them, we tend to be more upbeat, happy, and cheerful. And if we're around somebody that's got a little cloud over their head and they're always complaining and bitching and everything else, then that tends to subdue our own mood. Okay, the effective ongoing negotiator relations. So, expectations for approaching various personalities. If you face a competitive bargainer, signal early that you are willing to negotiate cooperatively. But keep information disclosures strategic and more circumspect until you can assess the true approach of the opponent. So this is a situation in which you really are feeling that tension between wanting to disclose what you need to get the most for your client and protecting yourself against exploitation, especially when the dollar bargaining starts. So remember the gains of one-upsmanship, and these are typical during initial meetings. This is to make you feel bad. Fancy business cards, boasts about law school background, boasts about their class rank, mention of impressive clients, or name dropping. And, the bottom line is, you know what they're trying to do. Don't let it bother you. And if this helps, you could think of it as a signal that the opponent lacks confidence. And if you've done your homework, then it doesn't matter what your credentials are because you're ready for this negotiation. If insecure, make them feel more comfortable, may lead to more beneficial terms for your client. So, there's lots of ways to do this. I'm not sure we've been talking about them to some extent over the semester. I think that we could elaborate on these more if we had time. Okay, so you can use an extended preliminary stage to build a relationship even with competitive bargainers. And, some people would say this is the reason for the 3-martini lunch in the old days. And there's several suggested approaches in the text, Craver text at page 69. And it can always help, and I don't think it's going to hurt unless you're a mean drunk and you've had too much to drink. All right, depersonalize the conflict, but personalize the bargaining interaction. So, in getting to yes terms, separate the people from the problem. Soft on the people, hard on the problem. The client's legal problems should remain the focus even when you are dealing with a jerk. Now, it always makes it harder, but if you can, kind of stay on your game, keep your eye on that prize, excuse me, then it can be easier to deal even with somebody who is really difficult to deal with. He talks about attitudinal bargaining. Describes an approach that encourages an atmosphere of cooperative bargaining while mitigating the potential effects of adversarial bargaining. As you'll see in the wrap-up class, other people have different ways of trying to capture this concept. And here I'm saying, yikes, one more name for collaborative or problem-solving technique. And one of the benefits of attitudinal bargaining, where you're supporting the relationship while you're trying to get the outcome, is it reinforces cooperative behavior. And we talked about puppy pats, or we will talk about puppy pats. This concept that when people are doing what you want them to do, you want to reinforce that behavior so they know they're on track. And a lot of people will call this kind of a puppy pat, like you would do when you're potty training a puppy. Positive reinforcement for the behavior that you want. The benefits of this approach: sincerely cooperative negotiators should take care that the other person is not a wolf in sheep's clothing who suggests cooperation but then adopts more hard bargaining tactics. And of course, you're going to be able to spot that. And if the opponent is more adversarial or competitive, then you can suggest a more cooperative approach by indicating your unwillingness to view negotiation as a combative exercise. So you can see that this is going to require a lot of leading on your part and a lot of good communication. And you may suggest some preliminary ground rules. And I haven't really distributed a lot of ground rules except the ones for a group. But at some time in the future, if you want to see a set, I'm happy to provide them. If you still must work with the jerk who has not adapted his or her style, then you can control your interactions with him or her. You can use phone and terminate the call if the opponent gets nasty, and you can call back after the opponent has time to cool down. This would be another reason to be at the opponent's office. If they get to be really unmanageable, then you can always leave. It's harder to do that if you've convened the negotiation at your offices, but you could arrange in advance to have somebody interrupt within a client emergency. And so you could get out that way. If you are working with a jerk again, you can use a large conference room table to manage personal space issues and keep an opponent from invading your space. So this might be a reason to use a much bigger table. All right, I want to talk a little bit about apology. I go into this more in my mediation class, But there are a lot of benefits of an apology, but it has to be sincere. So it acknowledges the other person's plight, and in doing so, well, I'm sorry, if you offer a simple, sincere apology, it acknowledges the other person's plight, but you have to make sure it's at least a 7 on a scale of 1 to 10. So in my mediation class, for instance, I'll ask somebody if they'd like to apologize to the other side. And they always give kind of a crummy apology in which they're not completely conceding their contribution to the problem. And so you can ask the person on the receiving end how they would rate it on a scale of 1 to 10. And if it's really crummy, it's going to be a 3 or 4. Maybe it'd get up to a 6. And then you ask that same person, what would you need for that apology to be a 10, a perfect apology? And then that person will say what they need to hear while the apologizer is listening in. And then you can turn to the apologizer and say, would you like to try again and see if you can formulate an apology that really meets, Mary's interests and needs? And a lot of times they'll shake their head yes and try again, and they'll get closer. Maybe it's a 7 or 8. At any rate, you can do this until they get the perfect apology. And usually by then, the parties are laughing. All right, in litigation, the party is likely frustrated and angry at the responsible party's inability to acknowledge his or her contribution to the situation. Now, sadly, in our tort system, often the defendant doesn't even show up in the settlement or mediation. They send an insurance adjuster who, I don't care how empathic they are going to have a difficult time standing in for the defendant. So what are the benefits? Let's see, what have I got here? The need not make an apology that is an admission of wrongdoing. Can acknowledge the opponent's pain without acknowledging guilt. Can empathize with their suffering, although this is much trickier than a responsibility assuming apology. So let me give you an example of this. I was handling a mediation that I'll call the show chickens case. And the plaintiff alleged that the defendant's dog had broken into his chicken coop full of show chickens and had killed a bunch of them. They were worth like altogether $3,500. And you'll have to remember, I live in an area where people breed cocks for cockfighting. And so we talked, we had the opening session, and he starts to talk about his facts, and he's got photographs of a dog standing over a chicken and the holes in the chicken wire and all that. And then the defendant said, that's not my dog. And he could still empathize with the owner's loss, but he wasn't acknowledging any guilt. And of course, that case let's just say it ended. And I don't think the plaintiff was satisfied with the outcome, but it was probably not a case that could be brought in the court anyway. All right, so Eastern cultures and women more freely offer apologies, perhaps because they value relationships more. So if you pay attention, you'll see just how often women apologize. Men or members of Western and individualistic cultures who have a hard time apologizing should understand that they may miss an opportunity to avoid litigation and negotiate a solution. Now, there's some data indicating that men, especially in Western cultures, have a hard time apologizing because it feels one down to them. And so they are much more reluctant to apologize. Make sure you know the rules governing admissibility of apologies into evidence at trial in your jurisdiction. And the federal rule is here. And this is basically what it says. I'm not going to go through it. You have to be careful. And in some states, they'll exempt apologies that are made in settlement or mediation, but you've got to check your state law. Okay, in conclusion, negotiation begins at the first in-person or other contact with the opposing party. Make sure you do it in a way to support the atmosphere you desire. And I say amen to that. All right, so that's all I've got. I think I'll come back on the screen. Yeah, here I am. Okay, so that's all I've got for this, and I hope that was helpful. And I hope that when you get ready for your capstone negotiation or other negotiation that you're contemplating, that you'll have just a terrific outcome and be the hero to your client. So bye now.